Good afternoon. I'm so delighted to welcome all of you to James Forman's inaugural lecture. And I thought I would just say a few words about what an inaugural lecture is, because I know there's some folks in here who might not know what it is. And for the students in the room, this is the first one we've had in a while. This chair was awarded a while back, but COVID prevented us from having a proper celebration. So for those of you who are wondering what a chair is, today we are naming James officially the J. Skelly Wright Chair. And in case you're wondering what a chair is, there's no reason that you should know. So when I was given a chair, which actually was the J. Skelly Wright Chair, I was the first person to hold it, I called my mom and dad. I was like, Mom, Dad, I got a chair. And having no academics in my family, their question was, well, there were a lot of chairs in your office. Did you have to pay for those? And now they're paying for your chair. And so I explained, a chair is an honorific, and it's something that you get at when you've really succeeded in your career, and it's a way for a school to honor you. And so then they asked me a question that completely stumped me, which was, so does a real chair come with it? I had no idea. The answer turns out to be yes, but I told them I had no idea, and as a result, my dad built me, in his little basement thing, the J. Skelly Wright Chair. So I have given James my formal chair, but this is close to my heart and remains in my office. So I want to thank everyone who's here. We have an enormous range of guests from different parts of James's life, but I want to give a special shout out to his family, to Efi, his wife, to Mecca, his son, to Constancia, his mom, to Terry, his father-in-law, and OBR, his brother-in-law, who've made some of them who've been here at a little bit of a distance to come and celebrate this moment. And I thought I'd just say a word or two about James before we let him speak. So before getting to talk about James, I should talk a little bit about why James holds this chair. So traditionally, when the dean becomes dean, she gets a different chair. And so I was going to lose my chair. And everyone said, the J. Skelly Wright Chair is such a great chair. You should hold it in abeyance while you're dean so you can take it back up again at the end. And I said, are you kidding? James Forman is here, and he does not have a chair. So I will be chairless when I finish this deanship, but I couldn't imagine anyone who better embodies the legend of Judge Skelly Wright. So for those of you who don't know, he was a civil rights icon. He carved a profound legacy in the annals of American jurisprudence. He was a judge for the Eastern District of Louisiana, and there issued the 1960 landmark order to integrate the public schools in New Orleans, a civil rights victory that forever changed the social fabric of his own hometown. The order earned him the hatred of many of his longtime friends and brought him into personal peril. Desegregation opponents burned a cross on his lawn so frequently that he actually had to have a police guard almost all the time. And apparently Skelly Wright, who used to say to his kids as he walked out, don't call the fire department unless the cross is really close to the house, which gives you some sense of what his life might be like. But he was undaunted by the intimidation and brought about the integration of New Orleans universities, its buses, its parks, its sporting events, and its voting lists. Fearing that Southern senators would block Judge Wright's appointment to the Fifth Circuit, President Kennedy elevated him to the D.C. Circuit. There, Judge Wright continued his pioneering desegregation work. In a ruling that has been known as the Wright Decree, Judge Wright ordered extensive reform to the district's public schools to address what he called the de facto discrimination that resulted from segregated residential patterns, and we have faculty in our own room who are the beneficiaries of that order. In the groundbreaking opinion, he wrote, racially and socially homogenous schools damage the minds and spirits of all the children who attend them and block the attainment of the broader goals of democratic education, whether the segregation occurs by law or by fact. In addition to striking down economic and racial segregation, Judge Wright's 38-year career curtailed sex and employment discrimination and expanded the rights of prisoners, tenants, and the poor. Judge Wright's unwavering commitment to unmasking covert discrimination and rooting out entrenched inequity continues to inspire generations of lawyers and jurists. He left the world a better place than he found it. This chair and the teaching fellowship that preceded it were established to honor him by inspiring students with the ideal of public service. When the chair was established here in 2008 by a gift from the estate of his wife, I was privileged, as I said, to have been the first to hold that position. And it really gives me a lot of joy to know that some of Judge Wright's clerks are here in the room, as they were instrumental both in making this all possible, but also in the extraordinary career that he led. Now, Professor Forman is one of about the only people in the universe who actually deserves this chair. He has, I like the shout out at the end, exactly. He has used his immense talents and his unflagging energy in the battle against inequity in our criminal justice and education system since the moment we all knew him. I could spend a lot of hours listing his accomplishments, but let me just give you the top line. He attended public school in Detroit and New York City before graduating from an Atlanta public school. He's a graduate of Brown and this law school. He clerked for Justice Sandra Day O'Connor and worked as a public defender for 6 years in D.C. He founded a public charter school in that city to address the root problems he came face to face with inside the Capitol's courtrooms. And in 2018, James won a well-deserved Pulitzer Prize for his extraordinary book, Locking Up Our Own: Crime and Punishment in Black America. Now, what this list of accomplishments cannot convey is what really matters. James is a person of exceptional integrity and decency. He has devoted his life to serving others. He is the finest of scholars and the finest of lawyers, and that is because he is the finest of people. As I often tell our students, no matter what you do in life, no matter what path you choose, try to be like James. Now, James devoted himself to challenging mass incarceration before that phrase was even coined. As a young public defender representing indigent juveniles and adults charged with crimes, he recognized the challenge that mass incarceration means more than challenging the mechanics of the criminal legal system. It requires protecting the civil rights of the most vulnerable among us. Most of his clients were members of DC's Black community, and he would later write, I quote, "As I saw it, I was a person in that courtroom fighting for Dr. King's legacy. I was the one doing civil rights work." His work there laid the foundation for his enormously impactful career, and many of those experiences in the criminal legal system are detailed in Locking Up Our Own. And for those of you who haven't read it, you must. It tells an incredibly poignant and nuanced story of why Black leaders supported the policies that contributed to today's mass incarceration crisis. The New York Times called it superb and shattering. I actually call it required reading, as I regularly assign it to all of the 1Ls for our pre-read in orientation. James's book tells the story of how, against the backdrop of our racial legacy, even in a city where Black residents are efficacious agents, they end up reproducing a dynamic that is all too familiar. Weaving together history and personal anecdote, James elucidates how agonizingly complicated the relationships are between race and policing, between race and class, between the small and understandable decisions that DC's Black majority residents made and the giant and incomprehensible disaster those decisions produced. He has made the world see these issues differently, and I can think of no higher praise for a scholar or a lawyer. Now, one thing to note is that James wrote that book when he was a member of the clinical faculty here at Yale. And to me, that provides the clearest proof that the qualities that make for a great lawyer are also the qualities that make for a great academic. And they are united in James. The ability to write about something even as you live it. The ability not only to think critically about one's own side, but to imaginatively and sympathetically reconstruct the position of the other. The ability to tell a story with integrity. At its core, the book is about getting proximate, to borrow a phrase from Brian Stevenson, connecting the legal with the human. And that's what James often does best. He makes it impossible to think that the law is something abstract, that its consequences are numbers, not people, that we are excused from the responsibility to engage directly and think deeply about the harms and plagues our schools and communities and prisons experience. James does this as a writer, a scholar, and a teacher. He so values education that on his book tour, he offers his book for free to students on financial aid who couldn't afford it. So, of course, most authors go on book tours to, sell books, not give them away. But James is not like most people. I often say that ideas are the coin of the realm here at Yale, and that our mission is to gather and support the thought leaders within their fields. And among those thought leaders, James has a particular genius for putting cutting-edge ideas into life-altering practice. James pioneered a class that brings a group of Yale law students inside a Connecticut state prison to learn alongside incarcerated people. The CAT class explores complex topics like the effects of over-policing and how to serve victims and survivors through restorative justice. It is a powerful expression of James's unmatched ability to ensure that all of his students get proximate with the issues they study. He doesn't just engage with the criminal system from 30,000 feet, he places himself and his students inches away from those whose lives have been intimately affected by incarceration. And James brings that proximity principle to his work in education as well, recognizing that underrepresented students face substantial obstacles to entering spaces of power and privilege. James helped found the Access to Law School program in 2020. So here in New Haven, where segregation and economic dislocation marginalize many communities, as James has observed, Yale students work one-on-one with first-generation, low-income, and justice-impacted prospective students. Under his guidance, aspiring attorneys from the greater New Haven area have learned to navigate the complex and oftentimes grueling paths to and through law school. And characteristic of James, he didn't make this program, he partnered with the students in this law school and the students in the program to make this a reality. And many of those students are here, and I wonder if they might just stand up so we can give them a big round of applause. I'll just note that this is only a fraction of what James does, so I'll just talk about one more thing. The Law and Racial Justice Center that he founded here at the law school alongside Director Kayla Vinson. The center brings together New Haveners, Yale student staff and faculty, local government officials, local and national experts in order to imagine and implement projects that advance racial justice. The center is in its early years, but it has already become a source of inspiration for this community. One of his latest projects is about thinking about what it would mean if we treated the many human beings being imprisoned less than a mile away from here as genuine neighbors. It is the kind of question that most people fail to ask, but again, James is not like most people. What's remarkable about James is that even as he makes so much of himself available to those in need, his colleagues, to his community, he still manages to be fully present with his students, and his students love him for it. His courses are oversubscribed each and every semester. One of his students wrote, "He brought tremendous empathy to the issues and people we discussed and taught us the black letter doctrine without for a second minimizing or obscuring the violence and immorality of the law." Students emphasize time and again that Professor Forman makes you feel comfortable, listened to, and challenged in his classes, and that he always speaks to you like you are in his living room. I'll close by noting that my old boss, David Souter, once said that the key to the common law was to remember the myth of Antaeus, the giant who drew his strength from touching the ground. Hercules could not defeat him until he had the wit to hold Antaeus aloft with his feet flailing uselessly in the sky. Now, Souter invoked the myth to emphasize the importance of facts to judging, but it is also a lesson for being a human being. It takes extraordinary humility for someone of James's remarkable reputation to keep his feet on the ground, to be present with every human being he encounters, to devote his life to serving others rather than chasing fame. Humility is not always a word we use to describe great lawyers and great scholars, but I consider it the highest form of praise. Ladies and gentlemen, please join me in welcoming James Forman.
Thank you. Thank you. I'm a little bit worried, though, that whatever is going to follow that introduction is going to have to be a disappointment. I just want to thank Heather for that overwhelmingly kind introduction and for the commitment to justice and to excellence and to inclusion that you have shown throughout your deanship. And thank you all for coming. It means so much to me. Today I want to talk about expanding access to the legal profession for groups that have been historically underrepresented, especially in light of the Supreme Court's decision in SFFA versus Harvard and UNC, which, as many of you know, severely curtailed the use of affirmative action as long practiced. But before we talk about today and the future, we need to talk about the history of exclusion that makes this conversation so urgent. Many of you know, I'm sure, the lawyers in the room especially, many of you have heard of the great Charles Hamilton Houston, who along with Thurgood Marshall and New Haven's own Constance Baker Motley and others helped devise the litigation strategy that would culminate in Brown versus Board of Education. Well, in 1928, decades before Brown, when Houston was a professor at Howard University Law School, he began trying to learn about the black lawyer population in the South. He surveyed clerks of courts in southern counties, writing them letters inquiring about how many black attorneys practiced in their courtrooms. And time and again, the answer came back, none. One clerk responded, "No Negro lawyer in this county, nor has there ever been. A Negro lawyer would be as much out of place here as a snowball." Another said, "No Negro lawyer in this county. Thank God." Now, this opposition to the notion of black people in positions of authority like law, it was expressed both formally in policy and also throughout culture and everyday interactions. So just to provide one type of example, during this time period, and for much of American history, black children were routinely told by white teachers that law and other professions were out of reach for them. There are dozens of examples of this, but maybe the most famous that some of you might even have heard of involves Malcolm X, born Malcolm Little. In his autobiography, Malcolm writes about being a student in Michigan with excellent grades. He was one of the only black students in his school, and he often felt out of place. But he had an English teacher, a white man, who Malcolm thought liked him. And he went to that teacher to talk to him about his career aspirations. And Malcolm said he wanted to be a lawyer. The teacher's response, which you can see here, was completely demoralizing, as Malcolm recalls it. It's part of why, hearing this from his teacher, it's part of why Malcolm says he gave up on school, eventually dropping out of high school. Now, of course, these anti-black prejudices and prohibitions, they didn't go unchallenged. I mentioned Brown versus Board of Education. Well, as some of you know, the groundwork for Brown was first laid in cases challenging black exclusion from graduate school education. In one of the cases that would reach the Supreme Court, a man named George McLaurin wanted to enter Oklahoma's graduate program in education. The state said no. Under the stated policy of separate but equal, Oklahoma said it'll provide McLaurin an education just as long as it wasn't in the same setting as what white students got. Mr. McLaurin sued, challenged the policy as a violation of the 14th Amendment. And under pressure and desperate to maintain segregation, the state of Oklahoma offered Mr. McLaurin a seat near that of his white students, but not with them. He studied in a separate alcove nearby. And the Supreme Court would eventually strike that down as not equal. Now, meanwhile, in Texas, Heman Marion Sweat was bringing a similar type of lawsuit to McLaurin's. But in this case, Mr. Sweat sought admission to the state of Texas's flagship law school in Austin. Now, Texas did not deny that Sweat was qualified. The president of the university, who you can see quoted here, said the only problem with his application is that he's black. Now, Texas was just as determined as Oklahoma had been to keep Sweat separate from its white law students. So in response to the lawsuit, Texas hired 2 black lawyers to teach Sweat, not in the law school in Austin, but in a few rented rooms in Houston. And on this side is an image of where Texas thought Sweat could reasonably study law. Now, naturally, Sweat and his attorneys rejected this. After all, what kind of education can you get if you don't have access to your classmates, to your professors, if you don't have access to the rest of the law school facilities, if you can't come into a room like this one? Now, so far, the things that I've told you about how black people were excluded from educational opportunity are in some ways a familiar story. Let's see if y'all can still hear me. Let's see if this lav mic works. Can y'all hear me okay? Yeah? Okay. So, this is in some ways familiar. The story that I've told so far is in a lot of ways the story that I learned in law school myself. And one thing about the familiar story is that the villains, the segregationists, those who would deny black people the right to learn, they're in the South. They're in Texas. They're in Oklahoma. They're in the Southern court clerks that told Charles Hamilton Houston that they would never welcome black attorneys. But that story is not the whole story. Let's talk about what was going on outside the South. Now, answering that question of what was happening outside the South would take more time than we have today. But I just want to focus on one small but important part of the story. I'm a local guy, as you know, as you heard, and I want to keep it local right here in New Haven and right here at Yale. So a century before, Sweat and McLaurin would try to break the color barrier in the Jim Crow South, here in New Haven, in 1831, black and white visionaries tried to advance black educational opportunity in another way. They tried to open what would have been the first college in the country for black people. For black men specifically, it should be noted. The idea for this college came from abolitionist organizers who saw how the lack of educational opportunities for black people was hindering black progress. So they spent 1830 and 1831 in various gatherings throughout the Northeast, hammering out the details for the college. These proponents of the college, they had a vision, a curriculum that would be founded on classical, agricultural, and mechanical education. And they had funding. Throughout 1830 and 1831, they raised money from supporters up and down the East Coast. They had land. They had identified a main building less than a mile from here, near the intersection of where I-91 and I-95 currently intersect. But the dreamers who proposed this college underestimated the anti-blackness of the era. One local newspaper objected outright to any initiative that would bring more black people to the city. Black people, they said, were a vicious population. The college would attract them here like bees to a hive, and they would bring with them vice, which the paper said was uniformly associated with a large colored population. Now, Yale, of course, was already here. And the proponents of the college saw that as a blessing. These dreamers had imagined that Yale professors might visit with and lecture at the black college. But Yale's presence would be turned against the effort, and Yale's leaders would play a significant part in leading the resistance. to the college. Now, one newspaper pointed out that Yale drew from wealthy white Southerners for its student body. They called them Southern planters, which y'all know from Hamilton. So let's call them plantation owners. They weren't going to send their sons to a city that was full of free, empowered, educated black people. In a similar vein, a Middletown, Connecticut newspaper argued, said, we don't want a situation where, and I quote, young ladies are to be elbowed at every corner by black collegians. On September 10th, 1831, the issue would come to a vote. New Haven's white male property owners gathered on the green to debate the question. Playing a significant role would be two men who would go on to help found this law school, David Daggett and Samuel Hitchcock. And like them, speaker after speaker denounced the idea of a black college. And as it would turn out, the vote was a rout. 700 people voted against the black college. 4 voted in support. And to quote David Blight, whose forthcoming book on Yale and slavery be released this Friday, I highly recommend it. September 10th, 1831 was a day when hope unborn was killed in New Haven. Poet Elizabeth Alexander asked us to imagine what New Haven would have looked like if racism had not carried the day. And I want y'all just to think about that. Imagine if a short walk from here we could point to the nation's first HBCU. Imagine if Dixwell and Newhallville and The Hill and Dwight, East Rock, Fairhaven. Imagine if anywhere you went in this city, you met people who said, oh yes, I'm a legacy. My great-great-grandfather and great-grandfather and grandmother and mother, they all graduated from the HBCU downtown. How that would have changed the city. But of course, American history and New Haven's history is more brutal than that. It's more tragic. And we are all heirs to the legacy of Daggett and Hitchcock and the 700 men who, when given a chance, denounced black education and thwarted black liberation. That inheritance is ours. It is in these walls. It is part of the chairs you are sitting on. It constitutes the podium where I'm standing. And what tied all these efforts together, from New Haven's opposition to a black college, to Texas's relegating Heem and Sweat to a basement outpost, to Malcolm X's teacher telling him that a black child should never dream of being a lawyer. What united those efforts was America's determination to keep its black citizens impoverished, to keep them down, to keep them second class. And in law, in my profession, the culmination of that determination looks a little bit like this. As you can see from this chart, black lawyers have been vanishingly rare for most of America's history. And the chart, in a way, it's not even complete because it doesn't even include the years before 1900, when there weren't even enough black lawyers to bother counting them. Now, the rise in black attorneys began in the 1970s, when slowly but measurably, as a result of efforts including affirmative action, black lawyers go from 1% of the legal profession in 1970 to almost 3%, then 4% by 2000, 5% most recently. Now, what you will make of these numbers is going to depend on your perspective. Because on the one hand, they show steady growth. On the other hand, the growth is late and slow. And even by last year, black people were dramatically underrepresented in law as compared to their percentage of the population. Law even lags behind other professions, which have their own problems. As Deborah Rohde pointed out, 2015, and what she said then remains true. She wrote then that 88% of lawyers are white compared to 81% of architects and engineers, 78% of accountants, and 72% of physicians. So this is a profession that has work to do. Now, so far, I've focused on race. And in particular, I've been focusing on the numbers for black attorneys where the historical record is the most well-developed. But the truth is that black exclusion is part of a larger story. Law and the legal profession have long been reserved for those who come from privileged backgrounds. So let's talk briefly about class or socioeconomic status, which has been left out of the conversation for too long when we talk about what it means to expand access to law and other professions. Now, one of the difficulties of talking about class is that until recently it wasn't even tracked. So, for example, if a school tells you that X percentage of their students are first-generation professionals, I can almost guarantee you they don't have those numbers from 5 or 10 years ago or 20 years ago. So there's no way to compare progress over time. Even the definition of what is a first-generation professional changes. Now, the fact that it wasn't tracked tells you something important. Schools didn't even think it was important enough to count. And here's one more reason we haven't talked about class. Sometimes, when people brought up class over the last couple of decades, they did so as part of a critique of race-based affirmative action. Right? They said, in essence, well, we should start focusing on class and stop focusing on race. And that alienated people who think we have a moral obligation to continue focusing on racial exclusion as well. So my perspective is a little bit different in this conversation. I believe that class-based arguments merit attention, not as a diversion from race, but on their own merit and in addition to race. The data that we do have, which is limited and contested, but the data that we have suggests that law schools overwhelmingly enroll students from wealthy and near wealthy backgrounds, while offering few spaces to students from poor, working class, or even simply middle class backgrounds. Now, this problem is the worst at the most elite law schools, but even if we look at all law schools together, we can see how dire the situation is. Consider this chart, for example, which is based on research done by UCLA law professor Richard Sander. So here we see the socioeconomic status of American law students based on an index that Professor Sander created that combines parental education background and occupational status. So on the left, you can see students coming from the lowest 25% percentile of American families. And all the way to the right, we see students coming from the top 10% of American families, again, as measured by this combination of occupation and income. You can see that only 5% of the students come from the bottom 25% of families, another 11% from the next quartile, 17% from the second quartile. Meanwhile, 39% come from the top 10%. This means, if you look at the numbers together, that more students come from the wealthiest and most educated 10% of American families that then come from the entire 75% below. For me, these numbers represent a national crisis. We are at a time when inequality in this country is sky high and yet still growing. And in the face of that, I think, those of us at universities face a simple but stark choice. Do we want to be part of a project that expands economic opportunity, or do we want to be part of one that further concentrates it? That's our choice. Now, as you all know, last term, the Supreme Court severely curtailed any consideration of race in the university admissions process in cases that were brought against Harvard and University of North Carolina. And much has been written and said about that decision, and I am not going to dwell on its particulars today. What I will say is this: the issues that I just spent 20 minutes talking about haven't gone away. Supreme Court decision doesn't change the fact that opportunity is unequally distributed. It doesn't change the fact that neighborhoods of disadvantage and concentrated poverty still exist. It doesn't change the fact that for some groups, including working class students, poor students, black students, Latina students, among others, are underrepresented in law schools. And while we can't be sure yet what SFFA's exact impact is going to be on the racial composition of universities, I think we can say for certain that it is not going to help. We don't know how grave the impact will be, but we know it is going to make things worse. So what are we going to do in response? I want to argue that this moment now calls for new, creative, imaginative thinking. I think this is a moment where we must try new experiments, lots of them. Some will work, some won't. But it's possible that we will emerge from this moment with fresh ideas that will endure. And I want to talk about one today, a program that you heard a little bit about when Heather introduced me, called Access to Law School. And I lift it up, not because it is perfect, and certainly not to suggest that one small program is sufficient to meet the setback that is the SFFA decision. No. I offer it to spur our collective thinking as a way of pushing forward a conversation about the kinds of things that we might do. And I offer it, most of all, in the hope that the idea sparks something in somebody in the audience, and it helps propel you to do something yet more powerful. The initial idea for Access to Law came to me when I was teaching law classes in prison. For many years, as you heard from Heather, I taught a class called Inside Out, in which law students from Yale and sometimes from Quinnipiac would spend a semester traveling each week to a prison here in Connecticut, either the federal prison in Danbury or a state prison in Enfield. And the class was made up of half incarcerated students and half university students. And over 13 weeks together, we closely studied the criminal justice or criminal legal system. And at the end of it, invariably, one or more of my incarcerated students would come up to me and say something to the effect of, "This class has made me interested in becoming a lawyer, but I have a criminal record. Could I do it?" And I would assure them that it was possible. And I would give them readings about and by people who had done it. I would teach them about Dwayne Betts, our alumni, who has gone on to so many great things. But over time, I came to see that while I was instilling belief, and that was important, belief alone is not enough. My incarcerated students were mostly poor. Many had received less than stellar educations. Almost all of them saw the LSAT as an impossible hurdle. They couldn't afford LSAT prep courses. They didn't have mentors to guide them through the admissions process. So, if I was serious about doing something to make it possible for them to become lawyers, I needed to do something concrete to make it happen. So in 2020, along with a wonderful group of 4 Yale students working in collaboration with me, we read a bunch of books and articles, and we canvassed the country, called everyone who would take our call, and put together a program that we called Access to Law School. It is, I think, the first program in the country in which law students working with a professor run a pipeline program to recruit talented, aspiring lawyers from the local community and prepare them to get into and succeed in law school. And Access is built around three core ideas. Number one, certain groups, as you've heard, are historically and currently underrepresented in the legal profession in New Haven, in Connecticut, and nationally. Second, this underrepresentation is not because of a lack of interest and not because of a lack of ability, but rather because of a lack of support and opportunity. And third, and crucially, there is something that every university in the country can do in response. One of my constant messages to students, and to my students in the room, I'm sorry, I know you've heard this already, but one of my constant messages is that in a world of too many injustices to count them all, you cannot do everything. You have to land somewhere and try to make a difference. And when you pick your place to land, please, for all of our sake, pick something you're good at. Well, we are a law school. I am a law teacher. Our students are obviously experts at the law school admission process. So if we are going to be good at anything, we better be good at helping people get into and succeed in law school. So let me tell you a little bit about who we work with in our program. We call the participants of our program fellows. And I am so thrilled, it is so meaningful to me that so many of them are here tonight. Some of our fellows have strong academic backgrounds, but many of them struggled in college. Some are decades out of college. Some overcame trauma, addiction, incarceration. And in our selection process, we don't require traditional measures of academic achievement. If you have that, great, and some do. But we also know that lots of talented people don't. So our focus is elsewhere. We look for grit, for drive, for desire, for an eagerness to give back to your community. So we work locally, so you can see 39 out of our 49 fellows are from New Haven. Most, 38, are first-generation college graduates. And every single one, all 49, would be the first lawyer in their family. And we also think about our work in terms of neighborhoods. So here I draw on the writing of my former colleague at Georgetown, Cheryl Cashin. In her book, Place Not Race, Cashin argues that efforts to remedy historical disadvantage should focus on neighborhoods. In particular, she says, neighborhoods in which people lack equal opportunity. Here in Connecticut, the Open Communities Alliance has identified neighborhoods by the level of opportunity they provide to their residents. They use indicators like poverty rate, crime rate, employment rate, home ownership rates, and based on that, they rank neighborhoods from very high in opportunity to very low. So this map displays displays New Haven and the towns around it. Some things are cut off, but you can see like Woodbridge there. For those of y'all that are living in Woodbridge, very high opportunity community. But as you can see, New Haven is mostly very low, and those pins that you see, those pins are the addresses for our fellows. As you can see, they disproportionately come from low opportunity neighborhoods. We've also analyzed the addresses of the cohorts. The median fellow lives in what the Open Communities Alliance would define as a very low opportunity neighborhood. Now let me be clear, these neighborhoods are rich with history and culture. They are full of people with energy and drive, people who care about their neighbors, people who are devoted to their children. But they are neighborhoods, because of the history that I've only briefly touched upon here, they're neighborhoods where it is harder to achieve material success from birth. Now, once they join the Access program, our fellows will be with us for 2 years. Here's a little bit about what we do together. So each fellow in the program is paired with a Yale student who becomes their admissions coach, their mentor, their ally. And the coaches and the fellows meet weekly. And these one-on-one relationships become the core of everything we do. I know there are going to be some fellows in the room who are going to nod when they say this, but the relationships with the coaches are what bind the fellows to the program when going gets tough. The second prong is LSAT prep. Of all the obstacles our fellows face in the journey, for most, not for all, but for most of them, the most daunting is the LSAT. And our LSAT work takes place over the course of an entire year. It combines small group classes, one-on-one tutoring, and self-study. And the third prong is the weekly Saturday academies, where we gather. My co-teacher, Kayla Vincent, we just had one in 129 this past Saturday. We all gather together, co-teacher, fellows, students, and we work step by step, methodically building a successful law school application. Here's a picture of, not this past Saturday, but last year's fellows and coaches working together here in room 127. Now, for anyone who's thinking, well, okay, this sounds like worthwhile service, but what's the academic component? Let me assure you that is there too. The Yale students take a weekly companion seminar, which Kayla and I teach, which is dedicated to studying the issues that make the program necessary, including a deep dive into the history of New Haven, deindustrialization, systemic racism, school segregation. The law students also learn the skill of running a program, which a lot of them are going to do over the course of their careers. One recent alum described it this way in her reflection about her experience. She said, being in Access to Law School is basically running a social change nonprofit, and I'm learning how to build and manage it from the ground up. I have also learned that for law students, the Access program can promote a sense of belonging, and in at least two ways. The first is that it promotes a sense of belonging here in New Haven. Students that I have learned over the years, and I said this myself as a student, students often remark on how it can be a city in which they pass through but don't develop a deep connection with. And they talk about how participating in this class helps them feel more connected to the city. And in a way I didn't expect, it promotes a sense of belonging at law school. You know, our program attracts law students who are disproportionately, not exclusively, but disproportionately first-generation students themselves. And many first-gen students walk into law school and feel like, well, maybe somebody made a mistake. Like, maybe I don't belong here. And many of our fellows worry about this too. Some of them wonder, do I really belong? I mean, I know they're running this program and they're telling me that I do, but maybe they missed something. Well, in our program, as coaches and mentors, the law students have to work with and teach fellows about overcoming imposter syndrome. And what we've seen is that for law students, teaching somebody else that they truly belong, that they will belong, is a powerful way, maybe the most powerful way of coming to believe it about yourself. Now, I've been speaking about this program about the benefits to law students, but it doesn't mean anything if we don't actually provide opportunity to the fellows. So what happens after we work together, Yale students, New Haven fellows, 2 years, being persistent and tenacious and passionate, holding high expectations, building community? Well, hopefully, law school. So these are the fellows from our first 2 cohorts who are now in law school. Ten more are currently in the application process, and I hope to have more photos to add to this slide very soon. And I want to say one thing about our theory of impact, because as much as I love this picture, and I just enjoy looking at it, in a lot of ways the picture represents only one aspect of the theory of change, because the picture encourages you to think about the individual, and it encourages you to think about the program as individual mobility, one student making that progress at a time for themselves. And that's part of it. But over time, I think that our impact will be community-wide. Each pin represents the address of one of our fellows. And as you know, New Haven is small. Right? Our fellows come from concentrated places. Many live in or from neighborhoods just around the law school. So our fellows, I believe, are a collective that will draw strength from their numbers. First 8, then 10, then 20, 30, 50, 100, over time, hundreds of New Haveners from underrepresented groups who have made it through law school and into the legal profession. When I think about the purpose of education, I don't believe that we do it for ourselves. Not only for ourselves, anyway. I believe that in part, we become educated for others, for our families, for our communities. And if we think of education in this collective way, then we can immediately see the power and the potential in a place-based effort like access to law school. Because I believe that our fellows, as a collective, will forever change this city. Not all of them will stay here, of course, but some will. And those that do will collectively change the kind of lawyers who practice here, change the legal services that are offered, change what it looks like when you walk into criminal or civil court downtown and you see a bar and eventually a bench that looks more like this city. Now, I should point out that while I have been talking about law school, there is no reason that a program like this should be limited to law. New Haveners aren't only interested in law. They haven't only been excluded from law. I would venture that there isn't a department or school at this university that couldn't do something like this. Or again, maybe something even better and more powerful. Yes, Arden, go for it. Nor is Yale the only university with such an obligation and opportunity. All across the country, city after city, you will find lavishly wealthy universities that are proximate to communities that lack financial resources. Here on this slide are just a few examples, just a few of America's wealthiest universities by endowment and their distance from the nearest under-resourced neighborhood. What if these universities decided that a core part of their mission was to resist the concentration of privilege and instead to serve as engines of mobility. That phrase, engine of mobility, is not one you will find on many university mission statements. I know because I looked. Otello in the back row, my fantastic RA, looked. But what if this were to change? Just imagine what American cities could look like. Now, in arguing that this current crisis presents something of an opportunity, I don't want to be naive to the challenges. We live in a country that enslaved people for more years than it hasn't. A country where people with class privilege work tirelessly to protect it. A country whose legal system has long been eager to entrench power and opportunity in just a few. And I know that I work at a university that sits in the middle of New Haven and where every year, on the first day of the Access to Law School program, including this year, I meet a fellow who is New Haven born and bred and who tells me, today is the first day I have been inside a Yale building. I am ashamed every time I hear that. Yale, I say, we have to do better. I know that this university, like so many others, has come to see its ability to exclude as a badge of honor, as a symbol of what makes it special, how many people we can keep out. So I know the obstacles to changing any of this are enormous. But I want to speak now especially to the students in the room and to the Access Fellows. And I want to remind you that alongside this story of entrenched power has always been a story of resistance. I am so lucky to, okay, y'all gonna know why she's clapping, because I'm about to tell you that I'm the child of civil rights workers, including my mother, who just started clapping. And through word and deed and applause at opportune moments, they have taught me resistance stories since I could understand words. This is my father being arrested protesting segregation in Atlanta in 1963. He and my mother were both in SNCC, the Student Nonviolent Coordinating Committee, one of the major civil rights organizations of that decade. They were an interracial couple at a time when those unions were illegal in many states in this country. And theirs was the generation that brought down Jim Crow, that brought us the Civil Rights Act of 1964, the Voting Rights Act of 1965, the Fair Housing Act of 1968. Congress passed those bills, yeah, the president signed them, yeah, but you can be sure that only happened because of years of mobilizing and marching and litigating and protesting. And when I think of their work and their effort, sometimes I think about a conversation that I had with my father a few years before he passed away. And we were watching a movie about the civil rights movement. And when it ended, I asked him, what'd you think of it? He said he liked it. He said he liked that they showed the history in film. He said more people watch movies than read books, which, now that I'm an author, I can tell you is definitely true. But he said something that he didn't like was how they made it seem like everybody was in the civil rights movement back then. He said it wasn't like that. We were few. We were unpopular. Even Dr. King, the most revered of all civil rights heroes, was unpopular when he died. Gallup did a poll. Dr. King had a 2/3 unfavorable rating in the months before he was killed. Even the famous March on Washington was unpopular when it happened. Roper, another polling organization that existed there, did a poll a couple months before the march. Here was the question: do you think the planned demonstration in Washington, D.C. will help or hurt the cause of the Negro? 60% of Americans said they thought it would hurt. Now, there were 250,000 people at the March on Washington. Y'all have seen the images. It's a lot. But a decade later, 10 million people would say they had been there. And my dad said, look, man, look, I am not telling you this because I want credit for being there first. That's not my point. He said, I'm telling you this because I don't want you to measure the righteousness of your cause by the size of the crowd. He said, I'm telling you this because I think the way they teach the history of the civil rights movement is demoralizing for your generation and for future generations. He said to me, look, those of you in your generation, you call a meeting and 6 people show up. And 5 of them were at the last meeting, the meeting where you planned this meeting. And then you see thousands of people marching in Selma and Montgomery. And you wonder, well, what's wrong with us? What's wrong with my cause? So my dad said, here is the thing. When you are fighting a deep and profound and apparently insurmountable injustice, people are going to tell you that change is impossible. If you ignore them, and you march, and you mobilize, and you litigate, and you educate, and you win, and you make the change, those same people who told you it was impossible, they won't admit they were wrong. No, now they're going to turn around and say, oh yes, I knew that was going to happen. It was inevitable. And they'll make a movie about it. So look, I don't know. I really don't. I don't know the idea that is out there in the audience that is more powerful and profound and transformative than anything that I have mentioned today. And I don't know who among you or what group of you is going to turn that idea into action. But I know that the idea is here in this room. And I know that the people are here in this room. And I know this, one of you, and it'll be a student or an Access to Law fellow, maybe working with others. One of you is going to develop that idea, and you are going to do something great. You are going to do something in pursuit of justice, something to expand access to the legal profession, something to advance civil rights and civil liberties in a way that would make Judge Skelly Wright proud. And when you do, when you achieve the thing that they told you would never happen, they'll make a movie about you. And when they do, please invite me to the screening. I want to be there, popcorn in hand. I will stand next to Dean Gerken. We will fill the theater. We will stand and cheer and applaud you and what you have done. Thank you.